We'll go ahead and get started. Thanks everyone for taking the time to join us today for our discussion on a look back on the past year in antitrust enforcement and what to expect in the year ahead. I'm Robert Baldwin. I'm a partner here in our antitrust practice in Washington, D.C. Let me just start off with a few quick housekeeping items. First, this webinar is being recorded, and we'll provide a link to the recording along with the slides from today's presentation by email after the webinar has concluded. Recordings of all of our past webinars are available on our website under Events and Webinars. We'll include a link to that as well. This webinar is also eligible for CLE credit, 1 credit. We'll announce the CLE code later in today's presentation and provide the forms and code in the email as well. We'll also leave time at the end of the presentation for questions. We received a number of fantastic questions in advance, which we've incorporated into the presentation already, but please feel free to use the Q&A button to add additional questions along the way as we go. Today, I'm joined by 3 of my colleagues in our antitrust practice. First, Lauren Battaglia is another partner here in the Washington office. She focuses on merger clearance, investigations, and counseling. Ashley Howlett is a partner in the Washington office as well, who also focuses on merger clearance. And Alice Wallace-Wright is a partner in the competition practice in our London and Brussels offices, who focuses on all aspects of EU and UK competition with a focus that we all share in tech, telecom, and life sciences industries, all industries particularly impacted by what we're talking about today. So today we're going to be talking about trends and predictions for enforcement in the US, the EU, and the UK. We've had a number of significant elections around the world, which will certainly impact antitrust enforcement in the year ahead. So let's go ahead and start in the US. Lauren, could you tell us a little bit about what to expect in the new Trump administration?
I'd be happy to. Nothing like starting with some crystal ball gazing. So for decades, we could pretty reliably depend on Republican administrations enforcing the antitrust laws less aggressively, generally speaking, than Democratic administrations. That was not broadly the case when we transitioned from the Obama administration to the first Trump administration. And frankly, I'm not expecting a sea change in actual enforcement during the second Trump administration compared to what we've seen during the Biden administration. You know, antitrust enforcement continues to be a bipartisan populist issue. And, you know, if we look back at the first Trump administration, you know, the agencies during that administration brought vertical merger challenges and aggressive tech cases. So we just didn't see that sea change before. And I don't think there's any reason to expect a full pendulum swing backwards here. More broadly, we kind of have the more populist wing of the Republican Party, you know, J.D. Vance, and you might have heard the term conservative. So there is a populist wing to the Republican Party right now that's very supportive of aggressive antitrust enforcement. But you also see others in the Republican Party that have been highly critical of, in particular, the current FTC. We've seen many subpoenas being issued, criticism about how resources are being utilized under the Biden administration. And we've seen a wave of challenges to the constitutionality of the FTC generally, and in particular, you know, the administrative legal process, the in-house legal process at the FTC. So there's kind of, you know, those are in tension with each other a little bit, but one thing that I am expecting is for the climate around M&A when it comes to antitrust enforcement to change. So a cornerstone of the Biden administration's approach to antitrust has been to not just aggressively bring antitrust cases, but also to affirmatively inject uncertainty into deal making, particularly with an aim to kind of broadly deter M&A activity. And we've seen this manifest in many ways. So, you know, we've talked before about those so-called close at your own risk letters that have been issued, where the agency is basically saying you're free to close, but we're not saying that we've closed our investigation, and reserving the right to do that going forward. More second requests being issued, particularly early in the Biden administration, where there was really no discernible antitrust concern in those transactions. And I think the other really good example of this is kind of the broad rejection of even structural divestiture remedies as a answer to antitrust concerns in deal making. I don't expect the second Trump administration to pick up that aspect of what we saw during the Biden administration. One way I've been thinking about this is that the antitrust climate around M&A is likely to change. But even if the day-to-day kind of enforcement weather when it comes to deals doesn't. So I think this is all reflected in the first antitrust nominee that was just announced yesterday. I'm not sure if we had inside scoop that was coming, or if we just got lucky with the timing of this webinar. But yesterday, President-elect Trump announced that Gail Slater was being nominated to head the antitrust division at DOJ. Notably, this is months earlier than we saw any antitrust nominations during the first Trump administration. I think it was March when Macon Delrahim was nominated to the same role, and it was October, I believe, for Joe Simons as chair of the FTC. So this is coming far earlier than what we saw previously. And, just a few notes on Gail Slater. She has real antitrust chops. She was in private practice a long time ago before joining the FTC as a staff attorney, and then as an attorney advisor to a Democratic appointed commissioner, Julie Brill. And then she had a series of roles after that, most recently as J.D. Vance's chief economic advisor. So in terms of that tension between the conservatives and J.D. Vance versus kind of the Republicans that have been more critical of the FTC, this is kind of an initial insight into where that's likely to land. And, so we shouldn't expect that she's going to pull back antitrust enforcement. She's, particularly when it comes to tech. And we don't have to guess about that because in announcing her nomination, Trump, made very clear that her role was to ensure, quote, ensure that the competition laws are enforced both vigorously and fairly with clear rules that facilitate rather than stifle the ingenuity of our greatest companies. So I think that's all consistent with what I was talking about before in terms of the climate around deal making, likely to get more friendly, even if we don't see a major rollback in enforcement. But now that I've been talking about the climate, Ashley, do you want to drill down on the weather? What are you expecting to see?
Sure. Thanks, Lauren. So I think I'll just drill down a bit more on what exactly we think might happen. And of course, we are looking into a crystal ball, or attempting to look into a crystal ball a bit on all of this. But I think we can make some predictions regarding what U.S. antitrust enforcement might look like in the Trump second term, just based on kind of the atmospherics and what we've heard and what we saw last time around. So at a high level, I think we anticipate that the Trump administration will likely walk back many of the more aggressive or novel Biden administration antitrust policies and initiatives, and go back to more of what we call kind of the traditional antitrust enforcement. And also, given that we anticipate new leadership at both the DOJ and FTC, including Gail Slater, as Trump announced yesterday, some of that gives us a bit of a clue as to what enforcement might look like in the Trump administration. So as a first thing, I think we can anticipate that the Trump administration will be slightly more merger friendly than what we saw under at FTC under Chair Khan and at AAG under Cantor. They both took a very aggressive stance to merger enforcement, and we can expect that the new administration may soften that a bit. As Lauren said earlier, though, antitrust is bipartisan, so I by no means want to send the message that this means that merger enforcement will come to a halt. I think they will continue to actively review and analyze mergers in this new administration. I think really what the real impact will be is that there will be a change in focus. So where we saw a lot of novel theories being brought up or used by the FTC and DOJ under the Biden administration, such as focusing on the impact of mergers on labor markets or heightened scrutiny of private equity. We might see some of that go away or at least be de-emphasized, and we might see more of a focus on just the traditional consumer welfare standard and other traditional theories of antitrust harm, especially in the merger context. Another thing that is possible is that the Trump administration may decide to either rescind or at least significantly revise the 2023 merger guidelines that came out under the Biden administration. The guidelines themselves really represent kind of a memorialization of the Biden administration's overhaul of merger enforcement. And we do know that when they were approved in 2023, they were approved by a 3-0 vote by a commission that at the time was all Democratic. So I think we can consider those to be pretty vulnerable in a new Republican administration. And we also do know that Melissa Holyoke was actually who is currently one of the Republican FTC commissioners, has said that she would consider rescinding or revising the guidelines and that she has a lot of concerns about them. Among her concerns, she stated that they rely on old case law and they are also downplay the role of economics in analyzing mergers. So I think to the extent the new Trump administration does anything with these, if they don't rescind them in full, I think we can imagine that they might focus on things like the increased or the change in presumption of structural presumption of illegality for mergers, or the de-emphasis of the distinction between the analysis of horizontal and vertical mergers. Just to note, if they do anything like that, especially if they wanted to fully rescind and prepare new guidelines, that's going to take some time. So this isn't anything that's going to be immediate unless they were to rescind them in full and just leave us with nothing there, which would create a lot of new uncertainty. We can also expect that to the extent they change the guidelines, they may also change the second request. So we saw in the Biden administration, the FTC and DOJ updated or added new specifications to the second request they issued that reflected some of the new theories that they had under the new merger guidelines. So if that changes, I think we'll see the second request change as well. And then also remedies will be back on the table. We'll talk a little bit more about that later, but I think that's something that will be an option again. As far as industry focus, we've seen recently heavy scrutiny on the healthcare industry and the tech industry, and I anticipate that will continue with the FTC and DOJ under the Trump administration. In fact, Trump has said, when he announced that Gail Slater's potential appointment, he said that big tech has run wild for years, and it's been using its market power to crack down on the rights of Americans, as well as those of little tech. He added that he was proud to fight those abuses in his first term, and he expects that will continue under Gail Slater's leadership in the second term. So I think tech enforcement is here to stay. And then lastly, I'll close just with what I don't want this message to be that a Trump administration represents weaker or less enforcement. I think it really just represents different enforcement. So where they might not focus as much on issues like labor, they may focus on new issues like ESG or other things that are just more relevant and important to this administration. So old issues may be replaced with new ones. And then also, I think that we can anticipate, and we've seen this already, the state AGs have become very active, and I think we can expect that to continue. So to the extent the federal agencies lessen their scrutiny or aggressive enforcement, we can expect that the state AGs may pick up where they left off. For example, the state AG could pursue an enforcement action in a merger where the DOJ or FTC decides not to take an action to block it. So that's some of kind of our crystal ball gazing and what we think might happen in the US. But I'll turn to Alice to tell us a little bit about what's going on her side of the Atlantic.
Thanks, Ashley. So on this side of the Atlantic, we've also had some new elected bodies too, albeit perhaps less headline grabbing. And as it relates to competition policy, we've a new European Commissioner for Competition, Teresa Ribera. The new commissioners were approved by the European Parliament on the 20th of November and took office on the 1st of November. So she's less than a week in. Ribera is a Spanish member of the Socialist Party and a senior member of the Spanish government and Minister for Ecological Transition and Demographic Challenge. The Commission President, Ursula von der Leyen, has announced that the Commission's first initiative will be what has been called a competitive compass, aimed at closing Europe's innovation gap with the US and China to increase security and independence and deliver on decarbonisation. These themes were highlighted in a tome of a report delivered by Mario Draghi, the former Italian Prime Minister, in September this year. The report also provides suggestions for how Europe's competitiveness can be enhanced through the competition rules, ranging from new procedural approaches and tools through to industry-specific approaches. Taking just one example, the Draghi report notes that the EU telecom sector is too fragmented and therefore companies lack the scale and funds to invest. He recommends a new Telecoms Act and a more lenient approach to consolidation in the merger control arena. He also makes some specific recommendations in computing and AI, energy, and in pharma. So the Commission certainly has its work cut out at the policy level with plenty of opinions and inputs on which it has to marshal in a politically and geopolitically challenging climate. There are some specific challenging political strategic calls coming up for the Commission in competition and digital enforcement, including in cases with the largest digital companies, as Ashley just mentioned, some of which, not all of which, Trump has been actively or implicitly supporting in their antitrust battles on both sides of the Atlantic. The Commission's mantra is dispassionate enforcement of the rules, and they will certainly not want to be seen to be changing course because of possible political tensions or backlash from the Trump administration. But there are some significant geopolitical headwinds to welcome in the new Commission. One point of difference, I think, as between the EU and the US, is that we can expect more in the sustainability arena, including on the competition treatment of sustainability collaborations. The European Commission, as well as national authorities, have published guidance on how they will analyse collaboration in the area with a view to encouraging it, and indicated that they will provide comfort to businesses seeking to collaborate to move the ESG needle. This is another area where the lack of alignment between EU and US policy poses really significant issues for our clients and risks given the global nature of many sustainability initiatives. Turning now to the UK, we too have a new government with Keir Starmer's Labour Party winning office in July. The government has a clear growth agenda across the piece, and competition enforcement has also received attention. The government caused some ripples in the competition community in October when Starmer gave a speech to global investors in which he promised to rip up the bureaucracy that blocks investment and to make sure that every regulator in this country, especially our economic and competition regulators, takes growth as seriously as this room does. Eyebrows were raised on how this message was intended and would be received by the UK's fiercely politically independent competition authority, the CMA. We've had some early indications from the CMA about how it fits into the government's growth imperative. They've announced a new growth-focused economics work programme focusing on the critical drivers and blockers of growth, including how easily or not new technology spreads across the economy, supply chain resilience, and how competition impacts investment. On the same day as Starmer's October speech, the government published an industrial strategy green paper, and the CMA responded to this in late November. And the CMA sees its role as twofold, providing advice to government on how to harness the power of competitive rivalry, but also direct use of their powers to promote growth, including through using their full enforcement toolkit, as well as in their approach to mergers. So there's an open question on whether we should expect more or perhaps refocused enforcement activity going forward. The CMA has issued far fewer enforcement decisions this year, and its pipeline is relatively limited. This is, of course, in part a result of the interaction between the general enforcement activity and the CMA's digital markets work. We're expecting the government soon to consult and issue on a strategic steer to the CMA. This is non-binding, but it might provide an insight into which industries and issues the CMA may prioritise in the coming year. I'm going to make some observations a bit later on what the UK's growth agenda might mean for transactions in our next section on merger clearances, but I will hand over to Robert to kick us off on that front.
Thanks, Alice. So when it comes to merger clearance in the US, certainly the first thing on our radar for 2025 is the new HSR rule change going into effect. So as many of you may know, in summer of 2023, the FTC announced a proposed rule that would significantly change, really for the first time in a meaningful way, the disclosure requirements in the HSR filings that parties are required to submit for pre-merger clearance in the US. The final rule, after much public comment, was finally issued in October 10th of this year. And the final rule will go into effect February 10th of 2025. It's certainly possible that this could get delayed by the Trump administration or walked back through the issuance of informal guidance or interpretations. But for now, everyone should assume that February 10th is the date that all these new rules will go into effect. Why is this happening? Well, the FTC in its final rule said that, essentially the HSR Act, which was passed in 1976, was no longer adequate in the disclosures that were required for understanding transactions now. The form of transactions has changed. There are many more, private equity firms, limited partnerships, LLCs participating in transactions, corporate forms that were not anticipated at the time that the HSR Act was passed. So a lot of the new disclosure requirements are intended to address that. They're intended to address innovation competition and where companies are developing products. So a lot of this reflects many of the trends that we're seeing in the merger guidelines as well. The rule change does not affect the reportability analysis, so whether an HSR filing is required. So if you had to submit a filing before, you still have to submit it now, and vice versa for transactions that were not reportable. What this rule change impacts is what parties are required to disclose if and when they do need to file. So it doesn't change who the ultimate parent entity is. It doesn't change who HSR associates are. It doesn't change the 30-day waiting period for most transactions. And it doesn't change the filing fees that parties are required to pay. But all of these new disclosures, the FTC estimates, will significantly increase the burden on filing parties and preparing the filings for the vast majority of transactions. So currently, the FTC estimates it takes about 37 hours for parties and their counsel to prepare an HSR filing. For most filings, they expect that it will take an additional 68 hours to prepare filings. And for transactions where parties overlap and sell competing products and services, it could take up to an additional 121 hours to prepare these filings. Now, many of us think these are conservative estimates for the time it will take to prepare the filings. So parties who are thinking of deals that are, in the early diligence stages now, that may sign in mid to late January, this is something parties should be thinking about now and taking into account. So a quick overview of what the new filing requirements will require parties to disclose. Lots of new categories here. If we could go to the next slide. So the new disclosure or expanded disclosure requirements are going to require additional types of documents currently captured by the item 4C, 4D requirement. So these are competition-related documents prepared for a transaction and prepared for a company's officers and directors. Parties will now need to include documents prepared for a supervisory deal team lead as well, or the person responsible for overseeing the strategic assessment of a deal. So that may pull in a non-officer member of the deal team. And for transactions that involve overlapping products and services, parties are going to need to submit for the first time ordinary course documents as well, whether submitted to the CEO or to the board, that in the year prior to the deal discussed competition-related issues. This is a huge new disclosure requirement, so companies that are preparing ordinary course documents now should keep that in mind. Even if they're not related to upcoming deals, they could be required to be disclosed. For the first time in the US, similar to requirements and filings in most other jurisdictions, Parties are going to need to describe the products and services that they sell, the areas where they overlap with the other party to the transaction. They'll need to disclose their top 10 customers and categories of customers in areas where they overlap, as well as supply relationships that exist with the other transacting party or the other transacting party's competitors. They'll also need to describe the strategic rationale for the transaction, and that means both for the parties doing the deal as well as their owners. So, for instance, if there's a private equity firm who's selling off a portfolio company, each of the private equity firm and the portfolio company will separately have to describe their strategic rationales for doing the deal. Parties will also need to describe officer and director relationships. They'll need to describe additional information about their minority shareholders and interest holders. This will particularly impact private equity and venture capital firms who, up until now, have had to disclose very limited information about their limited partner investors. There'll also be new disclosure requirements on foreign subsidies from certain restricted countries that the US government has laid out, as well as information on defense contracts. And lastly, what had previously been a voluntary requirement to disclose international antitrust filings, parties will now be required to disclose, to the extent that they are aware of any international filings required in a transaction, disclose that up front in their HSR filing. A couple other changes on the next slide that have come along with the new rule change. So we are seeing the return of early termination, which had been suspended since February 2021. So starting February 10th, parties may receive early termination again. This is for transactions that likely don't raise competitive issues. These are published publicly. And the FTC has also already released an online complaint portal where those in the industry, customers, suppliers, competitors can go on and complain about a transaction. A few practical implications. Obviously, here on the next slide, parties are going to need to consider whether to file before the new rule takes effect. They're going to need to involve counsel early in assessing whether there are overlaps and what the risks are in getting their deal done so that they properly frame that in the HSR filings. Parties need to be aware of what the new document disclosure requirements mean, especially for these ordinary course documents. So companies that prepare M&A pipeline documents, quarterly business reviews, be mindful of what's in those and what might need to just get disclosed. And consider tracking some of the information that we know we're going to need to include in HSR filings in the ordinary course of business. For those who are as passionate about the HSR Act as I am, we invite you to join us next Thursday for a deep dive on all these rule changes, what they mean, and recommended actions that companies can take now. We'll include information for that webinar in the email that will go out after this one. Lauren, a lot of companies who have already submitted their HSR filings have seen enforcement actions in this past year. Could you get us up to speed on what those actions have looked like?
Yeah, absolutely. I mean, clearly, the current version, soon to be old version of the HSR form has not held the agencies back from bringing challenges. I've listed out a number of the pending challenges over the last year. I think kind of just stepping back and looking at how this list of cases compares to what we saw during the 2021 to 2023 time period, these reflect a lot more of a traditional focus, traditional theories of harm that we've seen across past administrations. So a number of these cases really, the core issue that's being litigated relates to market definition. So Tapestry, Capri, and affordable luxury handbags, IQVIA, Propel, and kind of healthcare focused online advertising. These are really kind of more traditional market definition fights that we're seeing. A few threads that are pulled through from that earlier part of the Biden administration. Kroger Albertsons there, is a big, litigating the fix element of that case. We're still, that trial is over. We're still waiting on an opinion. Notable for that case, as Ashley mentioned earlier, we might see stepped up even from already aggressive state AG enforcement of the antitrust laws. And that's true for mergers as well. Here with Kroger Albertsons, you have parallel state AG cases also independently challenging that transaction alongside the FTC case. So keeping an eye on that one to see what it might tell us about what state AG merger enforcement could look like if we do see more of that under the second Trump administration. Tempur Sealy Mattress Firm is another one with threads being pulled from the earlier part of the Biden administration. This is a vertical case where the agencies are focused on whether Tempur Sealy might have an incentive to foreclose mattress competitors from being able to access Mattress Firm as an important retail outlet for those products. So these are all kind of more traditional theories of harm. I want to kind of double click on Tapestry Capri just for a second, particularly when it comes to these market definition fights. Notable there, as I mentioned, the market alleged by the FTC involved accessible luxury handbags, which on its face, I think anyone with any familiarity with those products could, have questions about how that market might be defined. But the judge in that case, in granting the injunction that the FTC sought, issued a very lengthy opinion going into depth on that market definition issue, and really put in a lot of weight on the parties' documents there. So, despite all of the economic analysis and other arguments that the parties had that wasn't a relevant market, that the FTC hadn't met its burden on that front, she really put weight on the parties' documents. And so if we go to the next slide, I just wanted to highlight this part of the opinion where she really discounted the parties' economic evidence on the basis of the parties' documents that showed that, accessible luxury was a term that was used throughout the parties' documents. Other documents showed that they priced in relation to each other, viewed each other as close competitors. So, this is, I feel obligated as an antitrust lawyer to highlight that documents are really important, particularly on market definition issues. But if we go to the next slide, I just want to highlight the data continues to show that a lot of deals are getting done. So we're seeing this shift in enforcement to more traditional theories in the second half of the Biden administration. But, if we compare this again to the first Trump administration, we're actually seeing a lower rate of second requests on deals under the Biden administration compared to the Trump administration. And that's true even in priority industries. So, only 4% of, life sciences deals that were actually cleared, so investigated by the FTC, received second requests compared to 15% earlier in the Biden administration. So the data is really telling the story that, even in this intense enforcement environment, a lot of deals are getting done. But I think it's also useful to look, again, across administrations. And so if we go to the next slide, we have some charts that really tell the story. So if we go to the next one. So I'll just note these charts come from Diana Moss, who is very pro-enforcement, but I think they're really useful in kind of painting the picture. So, remarkable consistency across particularly the last few administrations. So actually a slightly lower rate of second requests during the first half of the Biden administration compared to the Trump administration. Also a lower rate of challenges, again, as a percentage of the deals that were actually cleared to an agency for investigation. If we go to the next slide, I think this slide in particular is really useful to show that, we saw stepped up enforcement when we went from the second Bush administration to the Obama administration, and that was true. More second requests, more challenges, more deals that had to agree to remedies to get cleared, and a slight dip when we went from the Obama administration to the first Trump administration when it came to, actual litigated challenges, but still an uptick in deals that were abandoned, injunctions that were actually sought, and a slight dip again. On the earlier slides, looking at, second requests and actual challenges, a slight dip going to the Biden administration from the Trump administration. The notable outlier here is that big red bar dipping down all the way to the right, which reflects the Biden administration's policy of not accepting divestiture remedies in the case of DOJ at all, but in the case of the FTC, far fewer. So that's a really noticeable difference. And I'm curious, Ashley, what you have to say about what we might see in terms of settlements going forward.
Sure. Thanks, Lauren. So just to level set on where we are, as I'm sure people are well aware, the Biden administration has taken a pretty hard stance on remedies, going all the way back to January 2022, just after AAG Cantor stepped into office. He made the statement that merger settlements should be, quote, the exception, not the rule, and that DOJ would instead pursue litigation to block mergers that it deemed to be likely to harm competition. And then soon after, the FTC, Lena Khan at the FTC followed with similar language in an interview stating that she would sue to stop anti-competitive mergers rather than negotiate settlements with companies. And so with this tone set at the top of DOJ and FTC leadership, there's been a significant decline in antitrust merger remedies during the Biden administration. And indeed, as Lauren has kind of mentioned, the U.S. Antitrust agencies did not enter any pre-complaint settlements involving divestitures or other traditional remedies in 2023. And the same is true thus far for 2024. The FTC has accepted some merger remedies, although oftentimes not the traditional remedies, but they've accepted some during the Biden administration. But the DOJ has been particularly firm in its anti-remedy posture. So because of the agency's kind of preference or anti-remedy posture, we've seen that a lot of parties have had to move toward the fix, their proposed fixes being hashed out in court, or doing what we call the litigating the fix approach. And as Lauren mentioned, Kroger Albertson is an example of that from 2024. In fact, in that case, the parties came to the table knowing that they had significant that there would likely be antitrust concerns, and they had already anticipated divestitures and in fact contemplated those divestitures in their initial transaction agreement. But we saw that despite the parties' early offer to divest hundreds of stores and extensive remedy negotiations with the FTC, the FTC ultimately determined that the proposed divestiture or the remedy was inadequate, and they ultimately sued to block the deal anyway. So the parties were left with litigating the sufficiency of their proposed fix in court, or litigating the fix. We've also seen cases where parties have attempted to do what we call fix it first in the Biden administration as an alternative to traditional merger remedies. And so in a fix it first scenario, you have the parties voluntarily implementing a structural solution that eliminates potential competitive effects of the transaction before closing. And if it's satisfactory, then a fix-it-first approach can allow the parties to avoid the agency suing to block the deal, and also avoid having to enter a formal settlement agreement. We saw this happen this year in the Global Partners Gulf Oil transaction. And that one, after a long FTC investigation, the parties voluntarily, proactively amended their purchase agreement, and they dropped one of the petroleum terminals that they were seeking to acquire in the agreement. And soon after they did that, their fix, the FTC issued a press release focused solely on that fix. And the FTC Bureau of Competition Director said the FTC is pleased that Global Partners has abandoned its anti-competitive acquisition of Gulf Oil's terminal in South Portland, Maine. But they didn't, in fact, abandon their transaction. They fixed it, and they closed the transaction with the remaining assets that same day. Another thing we've seen this year with remedies is that the FTC has, in two cases, the FTC solved or closed a merger investigation with a pre-complaint settlement, but although they were formal pre-complaint settlement decrees. Neither of those decrees involved traditional merger remedies. One was the Exxon Pioneer case, where the FTC entered a consent decree to prohibit Pioneer's former CEO from serving on Exxon's board due to interlocking directorate concerns. The consent didn't rely on the typical or the traditional theories of the transaction substantially lessening competition under Section 7 of the Clayton Act, and instead focused on these board membership issues. The consent also didn't rely on Section 8 of the Clayton Act, which is usually the act used to enforce interlocking directorate issues, and instead they relied on Section 5. I think we'll talk about this later, but this is just another example of the FTC seeking to broaden its Section 5 power. And then we saw a similar thing happen in the Chevron Hess transaction, where the FTC entered a consent decree, a formal consent decree, but it didn't rely on the typical Section 7 concerns and focused again on interlocking directorate issues. So where do we see all of this going in the Trump administration? As we mentioned earlier, we do think the Trump administration, FTC and DOJ are likely to depart from the Biden administration's anti-merger posture and be more likely to accept them. In fact, we've heard from current Republican FTC Commissioner Melissa Holyoke that the FTC, she said the FTC should be pragmatic with respect to merger remedies and everything should be on the table. She also emphasized that the FTC's approach should not be trying to stop deals for the sake of stopping deals. DOJ and FTC could also reduce some of the uncertainty around merger remedies by reintroducing the prior Trump administration's 2020 merger remedies manual, or a similar revised document. That manual was withdrawn during the Biden administration as part of the agency's resistance to merger remedies. So we could see that or something similar coming back and providing more certainty on what a good remedy looks like. And then finally, given that the two Republican commissioners issued strong dissents in both the Exxon Pioneer and Chevron Hess transaction, we could potentially read from that in a Republican administration or in the Trump administration, we may see fewer of those novel remedies and things like what we saw there. Hopefully those were anomalies. So I will turn it to Alice from here to talk about what we're seeing in the EU and UK on merger control.
Thanks so much, Ashley. So I'm actually going to skip past the next couple of slides on EU and UK merger statistics, just to note that broadly the same number of cases are being reviewed in the EU as the US. And then on the UK slide, just how many cases the CMA is reviewing informally through its Mergers Intelligence Unit, which has really mushroomed this year. So moving on to the next slide on what's coming up in the EU and UK. In September, we had a landmark judgment from the highest European court, which was a rejection of the Commission's revised policy and interpretation of Article 22 of EU merger regulation. This policy purported to allow the Commission to review transactions that were not notifiable at either EU or member state level. It was designed to give the Commission the ability to examine deals relating to companies where the target's revenue was not indicative of the competitive role they played on the market, including but not limited to so-called killer acquisitions, where an innovative company might be brought up by a more established rival to stem its potential future competitive impact. The Commission noted this situation may arise in particular in the digital and pharma sectors. So the General Court had sided with the Commission's interpretation, but the Court of Justice overturned the lower court's judgment and concluded the broad interpretation of Article 22 was liable to undermine the effectiveness, predictability, and legal certainty that must be guaranteed to parties to a transaction. So where does this leave the Commission and companies doing deals which touch on the EU? So in the meantime, while this legal saga was going through the courts, many EU member states have introduced wider thresholds to address the concern the policy was targeted at, including Germany and Austria, who have transaction value-based thresholds, and other national authorities have the power to call in below threshold transactions. So the landscape's now completely different to when the Commission introduced its policy, and more deals would be within the competence of national authorities, and therefore referral to the Commission would still be available. So some have asked whether the Commission will now seek to formally revise its rules to address the perceived issues squarely. And our thought is that they will more likely take stock and see whether they are now able to take jurisdiction over the kinds of deals they were worried about using the broader national rules first, in part because any revision of the rules would be a multi-year project and require significant political consensus, alongside the parallel rules which are in place in relation to digital mergers. Just wanted to quickly note, because no transaction-based talk is complete without FDI and foreign subsidies regulation. Both of these are now part and parcel of any foreign filings analysis and absolutely need to be. FDI, often straightforward, but important to get right and build into any deal process. And on foreign subsidies regulation, we're now a year in, and the Commission says it's received 90 notifications in the context of transactions. But really, its focus has in fact been on foreign subsidies in the context of procurement procedures, where they have received more than 1,300 submissions. So then turning to the UK, I just wanted to pick up a couple of points. The first is just how flexible the CMA considers its jurisdiction to be, and this is a continuing trend. This is in a variety of ways, including establishing a nexus to the UK beyond revenue generation. This has been based on employees, research, or even just patents registered in the UK. And this is part of the CMA's answer on how to get jurisdiction over pre-revenue innovation cases. And importantly on this, several of the planks of the UK's new digital and consumer legislation come in January next year, and this includes new merger thresholds. And these thresholds further expand the CMA's ability to look at deals where the parties do not directly compete, which is the case at the moment, and where the target has no UK turnover, with a low bar to finding nexus to the UK. The second is in interpreting what a transaction is. And this year, the CMA have looked at a number of cases in the AI sector, including one in which they established jurisdiction based just on the recruitment of the co-founders and other employees in an AI company. All of this really is to say that the UK will almost always require an ever more careful look in any filings analysis. So just picking up a couple of the strands on mergers and the growth agenda. First, the UK government has been active in canvassing businesses' views on how the mergers process plays into investment. And the pretty universal view for the industry is that the UK process is long, unpredictable, hugely expensive, and opaque as to process and outcome. And senior civil servants have been actively and consciously visible and seeking input. And we've been engaging with the Prime Minister's Office for Trade on general points, but also on specific transactions. The final point to note before I hand back to Robert is that the CMA has announced that it will be conducting a review early next year of when behavioural merger control remedies may be appropriate, signalling, perhaps in contrast to the US position, a potentially more flexible approach to resolving issues in transactions. And just today, we have heard that the CMA has approved a really significant UK telecoms merger with novel remedies that commit the parties to delivering their pre-agreed transaction investment plan. So this is one to watch. Back to Robert in the US.
Thanks, Alice. Section 5 of the Federal Trade Commission Act has led to a similar battle of competing policy statements, similar to what Ashley mentioned with the change in the merger guidelines. The FTC Act in Section 5 prohibits unfair methods of competition, which in 2015, in the Obama administration, the FTC issued a statement saying that was, violations largely consistent or aligned with the other antitrust laws. In 2022, the Biden administration, after withdrawing that 2015 statement, replaced it with a new policy statement that broadly interpreted its authority to go beyond traditional antitrust violations, to say that the FTC did not need to demonstrate actual anti-competitive harm or market power in how it viewed conduct or merger control enforcement. This has led to a number of actions, the most recent of which being against pharmacy benefit managers and how they come up with formularies. But as with the merger guidelines, there's certainly the strong likelihood here that the Trump administration will withdraw that 2022 policy statement and revert to a more traditional view of what the FTC's authority under Section 5 is. They may reissue a statement similar to what the Obama administration had done in 2015 or stay silent on it. But again, this is yet another area where we expect the antitrust climate to revert to what was more traditional than what had been seen during the Biden administration. So that's what's going on at the FTC. Lauren, how about a little more on what's happening at DOJ?
Sure. I just want to stick a pin in one case that we're keeping our eye on up in Pennsylvania. The Biden administration agencies have made antitrust enforcement with respect to labor issues a key focus. Robert mentioned the non-compete rule out of the FTC. DOJ has brought merger challenges based solely on labor competition theories. And so I'm keeping an eye on one case up in Pennsylvania where the DOJ recently submitted a statement of interest in a private class action antitrust lawsuit challenging labor policies at a major health system up in that state. Specifically, the suit alleges that the health system acquired monopsony power, a fancy word for buyer power, through a series of acquisitions. And as a result, certain pretty standard employment terms and practices violated Section 2. In particular, their use of non-competes, tuition repayment terms, a no rehire policy. So there's no substantive ruling in this case yet, but DOJ submitted a brief suggesting that a series of acquisitions could be challenged under Section 2 of the Sherman Act, even if they wouldn't violate Section 7. So again, this picks up on the series of acquisitions point that we've talked about on previous webinars from the 2023 merger guidelines. It applies them in a labor context. So this is one that we're keeping an eye on. I think there's a hearing early next year. So stay tuned. And I think Alice, I think we're passing it off to you.
You are. Thanks, Lauren. On this side of the Atlantic, the rules on monopolization, or what we call abusive dominance, is really where the enforcement action is, and I think it's continued to stay. There are two areas I wanted to highlight. First is that the European Commission is using its really very flexible toolkit to find abuses in new circumstances, and it's typically focusing on the type of abuse which has the effect of excluding competitors, what we call exclusionary abuses. And they ultimately reduce competitive outcomes for consumers, not necessarily in the immediate or short term, but over the medium and longer term. Partly this is applying the existing rules to modern circumstances, for example, in the digital sectors. But beyond this, there are now lines of cases on certain behaviours which have previously not been the subject of antitrust attention, and a couple of these have grown up in the farm sector. We've had two cases this year on disparagement of competitor products by companies with a dominant market position. One was closed by the company giving commitments to cease the behaviour, and the other was the subject of an infringement decision at the end of October. Both of these cases related to statements made about the safety and efficacy of a competitor product, made to key stakeholders and customers, and which the Commission found had the potential to affect the competitor's ability to penetrate or expand in the market. There have also been recent cases on patent strategies designed to, in the Commission's view, artificially extend patent protection. The most recent decision at the end of October involved a strategy of withdrawing patents when they seemed likely to be revoked, so as to avoid a declaration of invalidity and prolong the challenge process for generics seeking to enter. Just finally in this space, we received in August the Commission's much anticipated draft guidelines on how it will apply the rules on exclusionary abuses. This guidance was intended and trailed as codifying the Commission's interpretation of the EU Court's case law and the Commission's practice rather than setting new policy. The previous guidance document was issued in 2008, so there was a lot to update. Perhaps unsurprisingly, the draft has been really pretty controversial, and companies and industry groups have not agreed with the approach the Commission has taken, or indeed with the Commission's view that it's simply a codification of the case law. The core of the guidance, which is new and has attracted attention, is on allocation of the burden of proof, including that certain categories of behaviour are to be presumed to be capable of having an exclusionary effect. This is absolutely a technical and legal and economic debate, but one which might have a significant impact for companies with high market shares. The feedback to the Commission has been so voluminous and pointed that it's possible the Commission will feel it's necessary to issue a revised draft early next year before seeking to move to finalise, which was previously slated for next year. So I think we've got a few minutes left, and over to Robert and Ashley for a roundup of other hot topics to be aware of.
Yeah, thanks, Alice. A couple other things we're keeping an eye on in the U.S. The first would be the non-compete rule, another area where we're expecting a quick flip-flop with the Trump administration in 2025. As you probably know, in spring of 2024, the FTC issued a final rule that would effectively ban nearly all non-compete agreements with a few limited exceptions in the U.S. That was scheduled to take effect September 4th. That did not happen because a court in Texas blocked the nationwide application of the ban. The FTC recently appealed that in October of this year. So the Trump administration could take several tactics here. One, it could withdraw the ban altogether. It could decide to withdraw its appeal, or it could let the appeal play out in the Fifth Circuit and possibly the Supreme Court, where it's expected to be overturned as well. So again, this is something that was a hot topic, generated 26,000 comments when the FTC released the rule, but in 2025, likely to see it die by the wayside. Ashley, what else are you keeping an eye on?
Thanks, Robert. So I want to just take a few minutes and talk about algorithmic pricing. It's become a hot topic, and it's gotten a lot of attention from regulators across the US as well as the EU and the UK. In fact, in July 2024, the European Commission, UK CMA, FTC, and DOJ all issued a joint statement on competition and generative AI, in which they stated that all four agencies are committed to monitoring and addressing the risk related to algorithms, particularly as they might relate to sharing competitively sensitive information, fixing prices, or collusion. So all of the agencies have their eye out on algorithms. The primary argument appears to be that if an agreement would be illegal if it were executed by humans, then it's still illegal if it's executed by algorithms. But we're seeing that companies are using algorithms in the pricing context and in other contexts more and more. So it's becoming a hotter topic. In the US so far, most of the algorithmic pricing enforcement to date has taken the form of private litigation. So far, we've seen it in the real estate context, hospitality, and healthcare industries, although the agencies have made clear that any industry is fair game for this type of kind of enforcement. In the cases that we've seen so far, the US courts have grappled with whether what the appropriate standard and what the appropriate legal framework is for analyzing these algorithms, including when we look at the Sherman Act Section 1, are we looking at a per se rule analysis, or are we looking at a rule of reason analysis? That's come up in many of the cases. In several of the private litigation matters, we've seen DOJ and FTC submit statements of interest in support of the plaintiffs. And in those statements of interest, they really took the liberty to try to outline their view of the appropriate legal framework for pricing algorithms. So just a few highlights from those. So they have argued that algorithmic price fixing is per se illegal under Section 1, where the defendants knowingly combine competitively sensitive non-public pricing information and an algorithm that they rely on to make pricing decisions with the knowledge and expectation that other participants would do the same. Also, according to the agencies, an agreement may be unlawful for purposes of Section 1, even if, and I'll tick through a few things, even if the participating competitors retain the authority to deviate from the algorithm's recommendations. And this is all kind of according to DOJ, FTC's view of things, not necessarily the courts. Even if the competitors adopted the algorithms at different times, even if none of the competitors communicated directly regarding their adoption or use of the algorithm, and even if the competitors only reached agreement regarding the starting point of their prices. So for example, if they only reached agreement regarding list prices or discounts, but not the final prices or retail prices, there still could be a Section 1 issue there. Most of the courts so far in the private litigation have declined to apply per se or apply the per se liability rule. And they have also not clearly adopted the DOJ or the FTC's legal framework. But in just to wrap up, in August of 2024, we saw the DOJ file what is the first federal agency enforcement action in this space. Notably, they didn't pursue a per se liability rule there. They were going under the rule of reason. And so I think all eyes are on that action right now. And I think, however it turns out, it'll tell us a lot about where regulation of algorithms could be headed in the future. So I think we're out of time, so we can wrap up there. We definitely appreciate everyone taking the time to join us today. The CLE code is on the screen. And as Robert mentioned earlier, we'll follow up with an email about other upcoming webinars, and we'll also circulate the slide deck. Thanks for joining.